Yeah, my name is Larry Klayman of Freedom Watch. I'm the counsel for Sheriff Joseph Arpaio in Maricopa County, Arizona. A few weeks ago, we filed a complaint for preliminary injunctive relief and other kinds of relief, as lawyers put it, to try to block the president's implementation of his executive actions, granting what is in effect amnesty to over 5 million illegal aliens. We are very thankful to the Judge Beryl A of the U.S. District Court for the District of Columbia, for scheduling the hearing quickly. We're confident of our chances of success at this lower court level, but whatever the judge rules, just to move this case along is important, because we have serious issues of constitutionality involved and the use of the Administrative Procedures Act. And we want this case to go to the higher court as soon as possible so this issue can be resolved. The lawsuit is not a case against Latinos or any other group. Anybody that knows me knows that I'm from Miami and I represented the Cuban American community and other communities. I'm not anti-immigration. I'm pro-legal immigration. And so is Sheriff Arpaio. I've never heard him make one negative remark about anyone of Latin origin or any other origin. But the constitutional issues here are super important, because it's only Congress that can enact laws. It's the president who executes those laws. And in this instance, the president, by his own admission 22 times before he so-called changed his mind, said that he's not an emperor, he does not have the ability to legislate amnesty for 5.1 million aliens, and that he simply had to defer. But when the midterm elections were over, just a month or so ago, he realized that he no longer had to play politics. He decided that he was going to become emperor again, emperor with new clothes. And as a result of that, he issued these executive actions, which go far beyond what Congress has authorized him to do. He's granted amnesty by declaring prosecutorial discretion. And I said to the court, you can't declare prosecutorial discretion for 5.1 million people. The president claims he's saving money by not prosecuting them. But the apparatus set up for that prosecutorial discretion requires a case-by-case review of 5.1 million people, potentially. Can you imagine the cost of that to the federal government? Notwithstanding the fact that you automatically get a work permit, which allows you to get a driver's license, which allows you to go to a voting registrar, and you're not allowed to ask questions, and you wind up voting as an illegal immigrant. That's not good for our system of democracy. It's corrosive. In fact, it's corrupt. But consequently, this law cannot be allowed to go into effect. And I told the judge that it's not an attack even on President Obama. And the fact that other presidents may have done somewhat similar things means that it should be done in this instance. That's not precedent. If you're breaking the law, whether you're President Nixon, who broke the law back in the time of Watergate, and to some extent got away with it, except having to resign, that doesn't mean that you can now break the law many years hence. So that's what I said to the judge. And I also pointed out that it's not just a question of constitutional law, but our Administrative Procedures Act is that when you come up with a directive to an agency which affects so many people, not just the 5.1 million illegal immigrants, but all of the United States, because, as I also stated, many of the people that have been in Sheriff Arpaio's jails, the illegal immigrants, after they serve their sentence for committing a crime, have been released, given to the Immigration and Naturalization Service, ICE. And since they were never deported, they commit crimes again, many of them, and wind up back in his jail. And this increased the cost of the sheriff's office. It puts a strain on their resources. And this sheriff's office, which is among the largest in the United States, can't afford that. It has immediate impact and negative effect, irreparable injury. So that's why this case is so important, is that under our Administrative Procedures Act, it's not just unconstitutional, but you have to give the American people who are so widely affected by this an opportunity for notice and comment as to whether this new directive of the president should go into effect. And if you don't give them 30 days notice, then the court should enjoin, that is, stop the executive action to allow for that. So I argued on two bases. This is unconstitutional, but even if it's not unconstitutional, the Administrative Procedures Act requires the American people to be able to comment and there should be a rulemaking here such that this law could go into effect properly and not illegally. And the bottom line is this, as the president said himself, he's not an emperor, he's not a king. Simply because he now has 2 years left and is not answerable to anybody, apparently not even his own party, many of whom are against this. 60% of the American people are against it because it's unconstitutional, a recent poll. The president does not have the right to take matters into his own hands and ram it down the throats of the American people because he thinks he's above the law. The president is not above the law. He's no different than you or me. As John Adams said, our great founding father and the second American president, in signing the Declaration of Independence, our new republic will be a republic of laws, not of men. The president should read what Adams had to say, and he should take heed, because this is not something that this country can countenance, and if it continues, we're going to destroy our constitutional republic.